You miss one, I'm putting you in. I'm not even listening to any excuse as to why you didn't get there. If it comes back with any alcohol in your system, you're going.
It'd be counterproductive for me just going to jail.
Well, what you're doing is your life is counterproductive right now. Your name?
Daniel Heelan, sir.
Take your hands out of your pockets, please. What are we doing?
Your Honor, we're asking for a brief adjournment to continue plea discussions with the people.
July 9th.
Support receiving the bond violation report. Quantified progress report was done to change the defendant's most recent past, which was positive for an ATG.
Is it, you been drinking?
Yes, Your Honor.
You're not supposed to be kept. Did you see it?
Yes, Your Honor, I have had a chance to see the report. I too interpreted the positive for ETG not to mean that he actually just took a test, but that it came back positive for alcohol. Mr. Heelan does, as he just told you, he did drink. He is working. He has a prescription for the other substance that was indicated. He is working to make positive change. We ask the court to consider his unequivocal and honest response to the court in regards to the violation, and perhaps give him an opportunity to continue testing, remain outside of custody, and continue dealing with these matters.
You completed Bear River?
Yes, Your Honor. You know, I know I've still made a lot of progress, Your Honor, and I'm not making any excuses, but I'm not using much worse things and doing much worse things. And again, not making excuses. I've just been going through it. I'm still waiting on my place. I'm just right there, and I just got changes on the way. I'm going through it, Your Honor. Again, not making excuses. I own my actions.
I think he is in line for a voucher or a subsidized housing unit, Your Honor. We thought it was going to be Miller Manor, but it appears it'll be Arbordale now. But he is where? Arbordale?
There was a clerical error, Your Honor.
Oh, I got it.
Your Honor, we've been here a few times over the last month or so. It looks like on 514, my notes indicate he had not been going to community corrections. He was ordered to appear in person, and then we understood that he was testing at home of division, but those results were not being released to community corrections.
Right.
Then on the 21st, we're back again. The home of division results were supposed to have been sent over. I asked for a test that day, but the defendant had no money to test. The court was very sensitive to the housing needs of the defendant and did not want to mess those up. So the court allowed him to stay at liberty. The concern of the people now is that we haven't really had any. The tests that we've had since Bear River have just been since the 21st of May. We do have this positive alcohol test, and as sensitive as I am to the defendant's need to secure his housing voucher, the concerns I have are the support that he's getting. It seems like it's not a sufficient level of support to keep them from drinking or using drugs. So I am concerned about his ability to remain compliant with his bond conditions.
At this point, Judge Simpson shifts the hearing away from sympathy and back to accountability. Notice that he doesn't spend much time debating whether the defendant has made some progress. He acknowledges it. Instead, he's examining a much more important legal question: whether the defendant is actually complying with the conditions that allowed him to remain out of custody. That's a critical distinction in bond violation hearings. The positive alcohol test isn't necessarily being treated as an isolated mistake. Combined with mistesting, inconsistent reporting, and ongoing supervision concerns, it begins to form a pattern rather than a single lapse. Courts often evaluate patterns because they reveal whether someone is genuinely reducing risk or simply avoiding consequences. The defense is trying to frame the defendant as honest, motivated, and dealing with difficult personal circumstances. That strategy can be persuasive, but only if it's supported by consistent compliance. Do you think admitting the violation voluntarily strengthens his credibility, or does the documented pattern outweigh that honesty? That's exactly the balance the judge is weighing before deciding whether continued release is still appropriate.
Your Honor, he is, as indicated, is working with Home and New Vision according to the bond report. It appears that Home and New Vision has released the results to Mr. Heelan, and those have been sent over. I didn't quite understand the language in the bond a report that they will have to apparently go through. The way I read it was they'd have to go through Home and New Vision to him to Community Corrections. I don't know if that in fact is the case. I don't know if they would perhaps agree to release them to me so I can send them along. But that was a bit of an unusual circumstance when I read it, and I got it yesterday afternoon, so I didn't really have a chance to follow through.
I tried to get them released. I'm trying. It's a headache. I'm trying to get them to just straight release them at all.
How often have you been drinking?
Not often, Your Honor. I was actually just.
Well, no. Listen to me. How often are you drinking?
Not often, like a couple of times, period. Like, I'm not a big drinker, Your Honor. I'm trying, Your Honor. I'm trying so hard. I just going through it. It was a 1-year anniversary of my father passing, and I'm not making excuses. I went off the hinges a little bit, but I'm trying to keep moving forward. Again, I haven't gone back to the worst things, and I'm proud of myself for that, but I was very disappointed in myself.
What type of treatment? You're at Home and New Vision. What type of programming are you in over there?
Intensive outpatient. I see Elizabeth Aoki specializes in intensive outpatient treatment. I just really started with her. I'm just.
How often are you seeing her?
Once a week, sir.
Anything else during the week?
I've been attending some meetings. I'm trying to find some.
How many supposed to attend?
I mean, I don't have a supposed to, but I should be going to one.
You want to stay sober.
At least.
How many meetings should you be attending?
At least one a day, sir.
And how many meetings have you been attending?
About one every 3.
So bottom line is you're not doing the stuff to even help yourself right now.
I need to step it up. I need to step it up.
So if you've been doing this, tell me why I shouldn't put you in jail today.
This is the turning point of the hearing because Judge Simpson stops discussing alcohol and starts analyzing personal responsibility. The judge isn't simply asking whether the defendant relapsed. He's testing whether the defendant is actively using every available tool to prevent another relapse. Listen carefully to the sequence of questions. How many counseling sessions? How many recovery meetings? How often are you attending? Those aren't casual questions. They're designed to measure commitment. When the defendant admits he believes he should attend daily meetings but isn't actually doing so, he unintentionally weakens his own argument that he's doing everything possible to stay compliant. From the court's perspective, treatment only has value when the participant consistently engages with it. Good intentions cannot replace measurable effort. That's why the judge's focus shifts from addiction itself to behavior that demonstrates accountability. The defense continues to argue that incarceration would interrupt the defendant's progress and jeopardize his housing opportunity. But the prosecution's concern is equally clear. If the defendant isn't following the recovery plan while free, why should the court expect different results going forward? Which argument would carry more weight with you if you were making this decision?
It'd be counterproductive for me just going to jail.
Well, what you're doing with your life is counterproductive right now.
Still making some positive progression. I am making positive progress and I'm trying hard.
Where's your housing thing right now?
I'm right there. I've just did the new referral packet. There was a clerical error. They didn't have units available, so I kind of had to start over, but I'm right there. Like within the next week or two, I'm going to have my own place for the first time in a long time.
You don't get that housing, that's going to be an absolute disaster for you, isn't it?
Yes, Your Honor.
Even more so than what you're doing with your life right now.
So bad, you know. I just want my own place so much. I'll be able to work. I'd be able to take showers and actually be able to function. Just want my own place so bad.
Why are you messing it up?
That's a $1 million question, Your Honor. But the flip side of that is I know it's a mess up, and I'm honestly reconciled with myself, and I'm trying. And I've talked to Elizabeth. I'd like to start seeing her twice a week, but there's a full schedule. That's right now. She just got to work that in, and I really do know that I've got to step it up, and I'm willing to do that. The reason I haven't been going to any meetings is honestly, I don't have a lot of transportation, and I don't.
You can walk to a meeting. There are meetings all over. You can walk to a meeting.
Well, I'm trying to find.
I'm not.
A new one.
I am not going to even hear that. Because you know that's not true. You can walk to a meeting. There are meetings going on all over the place. Here's what I'm going to do. In order to defendant is to report over to community corrections placement on Scram Tavern.
Thank you.
And I want you to get a sign-up sheet and have it filled out that you've attended an AA meeting every day from today forward to the adjourn date. You're to bring that with you to your adjourn date, and I want to see it. Follow me? Miss a day, I'm putting you in. Comes back, take your hands out of your pockets. You miss one, I'm putting you in. I'm not even listening to any excuse as to why you didn't get there.
Sure.
If it comes back with any alcohol in your system, you're going. I'm just going to let you know how I'm going to handle it. Because I'm not sure I should be giving you this chance.
Thank you, Your Honor.
Adjourn this to July 2nd, 2026, 9 a.m.
To report to community corrections right now, Your Honor.
Yes, he needs to report right now. Don't leave here without going over.
Sure.
I have given him instructions.
Thank you, Your Honor.
Thank you, Your Honor.
Judge Simpson ultimately chooses accountability over immediate incarceration, but this is far from a free pass. Legally, the court finds that the defendant has already demonstrated enough concerns to justify serious consequences. However, rather than revoking his release immediately, the judge creates a structured final opportunity to prove compliance. Notice how specific every condition becomes: daily AA attendance, immediate reporting to community corrections, scram monitoring, and an unmistakable warning that any missed meeting or additional alcohol use will result in custody. These aren't suggestions. They're measurable conditions that eliminate excuses and make future compliance easy to verify. Another important legal principle is visible here. The judge repeatedly considers the defendant's housing voucher because stable housing can significantly reduce the likelihood of future violations. At the same time, he refuses to allow that opportunity to become a shield against accountability. The message is clear. The court will support rehabilitation, but only when the defendant demonstrates equal commitment. The defendant's honesty likely helped preserve this final chance, yet honesty alone wasn't enough. The judge required concrete behavioral changes backed by documentation rather than promises. For anyone watching, this hearing highlights an important lesson. In probation and bond supervision, courts don't simply evaluate whether someone wants to change, they evaluate whether daily actions consistently support that claim. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.